So my name is Keith Rabelais, and I'm a venture capitalist, which might be a weird sort of mix for this crowd. But I did start my professional career, and the reason why I immediately accepted the invite to introduce the Honorable Edith H. Jones was I started my entire professional career clerking for Judge Jones. And many of the lessons I learned that became fundamental in my career were actually lessons that she taught me that I don't know whether you knew or not you were borrowing from Calvin Coolidge. So I'll highlight a few. Well, I'll go. I'll see if I hit a few highlights. But the fundamental things is in an age of ChatGPT, I'll gloss over or rapidly cover the obvious things you introduce a judge. You know, President Reagan nominated her in 1985 when I was still a young kid. And she served as an active judge for approximately 41 years since, which I think by my count puts her fifth on the all-time list, fifth or sixth. But more importantly and very timely, we've witnessed over the last year what happens when judges sort of usurp their proper role and engage in a coup. And I think the fundamental reason that that hasn't happened for 70, 80, maybe 90 years is that people like Judge Jones actually were a bastion fighting back and preventing it. And now as the courts have changed, as the world has changed, as unfortunately the various presidents have changed, there's less people able to edit the work of some evil people. But fortunately, she's been very successful. I witnessed a few successes that the arc of history would have been different absent her service to the country. The two most important lessons, well, let me say one thing personally. The best way to describe Judge Jones, for those who don't know her well, is it's basically my grandmother meets Margaret Thatcher. And I used to describe this like 25 years ago, or 30 years ago. And the reason why is she has the kindness and warmth of my grandmother. For example, when I was clerking, she called my mom and was concerned that I was losing too much weight and that I wasn't eating enough. And, you know, on the judicial salaries at the time of $34K, maybe that was a reasonable thing to do. But I actually weighed 20 pounds less than I currently do. And the feedback from my mom that was provided by Judge Jones actually was pretty useful. And then the steely principle of Lady Thatcher and the ability to say no, basically. Say no to modern trends, to modern, cool, the sort of trendy thing to accept. Lady Thatcher's most famous, important phrase is no, no, no. And, I actually subtly picked it up from the judge and from Lady Thatcher and didn't even know where it came from. My kids literally mimic me saying no, no, no. And I didn't really understand the derivation until I was watching The Crown, season 5. And there's a scene where Lady Thatcher says, no, no, no. And I'm like, oh my God. And like my husband looks at me, he's like, oh my God, that's where it drives from. So the lesson of saying no when everybody wants to go one way and you know it's wrong is a foundational element of my career, but I learned it from Judge Jones quite personally. There's two key lessons from Calvin Coolidge, though. The famous quote that everybody cites is, "You can't pull up the weak by pulling down the strong. You can't build up the weak by pulling down the strong." We just witnessed, New York City's going to try to do that. It's not going to end well. Judge Jones, actually, when I was clerking, you probably will remember this, said, "Keith, envy is a sin." And that stuck with me every single day. I use that line almost every week. And once you understand that envy is a sin, it clarifies almost every policy debate. It clarifies almost every bad idea when you just bake that into your brain. And it really does put people on the defensive when you replay back to them what they're actually saying is, I'm envious. The second thing is, of course, the right thing to do never requires subterfuge. The direct and simple answer. I used to be a sort of precocious but a little crazy clerk and would want to find all these fancy words and would draft all these opinions, and the judge would take out a pen and would edit every fancy word that I discovered in my reading over the weekend. And she's like, we use simple words. And it took like about a year, and I finally got it trained. But the more important lesson from President Coolidge and from Judge Jones is when truth is on your side, simple works very well because it's powerful and direct. And when truth's not on your side, you have to obfuscate. And fancy words and fancy thinking are always an attempt to obfuscate. Like an example of this, and maybe the most recent example I can think of, is imagine if the Wuhan Institute of Virology had a different name, we would probably still be debating what the origins of COVID were. But because they were dumb enough to name it correctly, everybody basically understood that all the nonsense of all the media, of every left-wing organization and the government just had to be wrong. And so that's the opposite example of using simple, direct language when truth's on your side. And so I learned that also from every single draft getting edited. And so without distracting too much more, I think there's probably nobody better than to apply the lessons of Calvin Coolidge to today's modern times. And with that, it's my absolute pleasure to introduce the Honorable Edith H. Jones.
Well, with an introduction like that, I hesitate to go any farther. I'll just sit down. Okay. Thanks, Todd. Clerks are not allowed to ask questions later, by the way. There's still a couple more seats if people want them. I want to thank Amity and Matt Dennard, who's not here this evening, and all the people with the Coolidge staff who have been my friends for a number of years now, because I've been on the board of the Coolidge Foundation for a number of years since Amity took over as president. Amity Shlaes is a treasure to our country. Very few people can mix sound economic journalism with a real depth and appreciation of the emotion and grit of history in the way that Amity has done in many of her books. She and I became friends when I read The Forgotten Man, which detailed the errors, the serious economic errors of the Depression right on the cusp of the financial meltdown of 2008. It was actually prescient, and we've been friends ever since. Amity has done a wonderful job with this foundation, transforming it into an institution to educate young people about President Calvin Coolidge, his virtues, his admiration of the founding generation and the Constitution, and the presidential policies that took the country into an enormous period of economic success. Well, and I also need to thank the benefactors, my former law clerks. I can't express in words my gratitude for their generosity in having decided to endow a series of lectures. I just can't express it. Everybody here in the room tonight made a serious contribution. My former law clerk, Justin Braga, is not here this evening. He's a lawyer in New Hampshire who had this idea after he became a fan of the Coolidge Foundation, but work kept him away this evening. And particularly Keith has been probably the sine qua non contributor to the series, for which I'm extremely grateful. I would like to talk to you tonight about what Calvin Coolidge was, how Calvin Coolidge was trained in the law. People don't pay much attention to the fact that he became a lawyer. He didn't really emphasize it once he got into public life, but he was a member of the last generation of American lawyers who read for the bar, a period when most lawyers did not have the privilege of going to law school. He practiced law in Northampton, Massachusetts for approximately a dozen years until he entered public service full-time. When he spoke about the law or the rule of law, his remarks illustrate a perspective that even then in the early part of the 20th century was being challenged by progressives and legal realists. I'm going to call Calvin Coolidge's perspective the founder's law. Eventually, however, the realists and their descendants' perspective took over and have dominated legal thinking throughout the 20th century to not very good effect, in my view. It's my hope that this lecture will serve two purposes. First, I would hope that future speakers can do more to enlighten the public, and especially aspiring young lawyers, about the founder's legal heritage, which shaped Calvin Coolidge. In broad terms, this framework understood a connection between law and objective standards of morality. Second, I believe that speakers can suggest how a renaissance of these fundamental principles of the founders' legal heritage can offer specific remedies for failures of 20th century legal scholarship. So to start off this series, I will begin with a cursory review of the authors whose works educated Calvin Coolidge. Those are William Blackstone and Chancellor James Kent. And then I will explain how President Coolidge responded to their training and sketch the divide between the founders' law and the modern thinking that took over. Now, I am not speaking for historians. I am not speaking about philosophical ideas because those are beyond the scope of what I have studied for this purpose, but also beyond the scope of what lawyers who were being trained for the law, like Calvin Coolidge, were talking about at this time. So just take that in mind. What we know about Calvin's legal training is that when he decided to study law, paying to attend a law school was beyond his and his father's means. The option he took was to become an apprentice with a firm called Hampton and Field in Northampton, Massachusetts. The town had a thriving business community. It was hospitable to inventors. It had educational institutions like Smith College, and its status as the county seat assured that there was a varied and interesting practice of law. He read law from 1895 to 97 and passed his examination a year earlier than was usual. How did one learn the law? By reading. At the time, the principal mode, as I said, had been an apprenticeship under the tutelage of Hammond and Field, who were Amherst grads like President Coolidge. He drafted pleadings, he studied Massachusetts law, and he attended numerous court hearings. But for general legal knowledge, he read treatises. In fact, like all American lawyers of the time, he absorbed Chancellor Kent's commentaries on American law, which had been published between 1826 and 1830, and he read Blackstone's commentaries on the law of England, originally published from 1765 to 69. Both of those formed the framework in which he thought about the law. Each set of commentaries covered the entire scope of legal topics in England and the United States. Both were written in easily accessible language. Now, the law of that era is complex, but the language is very accessible, as you will learn as I paraphrase some of it. These texts are not daunting to the non-legal reader. In fact, they were written to educate gentlemen, that is to say, all who wish to participate in government at the time, whether as trained lawyers or citizens. And both of them, by the way, drew heavily not only from the English common law tradition, but also from the best thinkers on law in Europe and the classical tradition as well. I start with Blackstone. His 4-volume work was not the first to address English common law development, but Blackstone, as Kent wrote later, is justly placed at the head of all modern writers who treat of the general elementary principles of the law. Blackstone, his task was to organize and synthesize a century of English common law, the legal relationship between the Crown and Parliament, and what there was of statute law. Before his commentaries, and despite the efforts of many early chroniclers, the common law was disorganized and difficult to fathom. As Chancellor Kent said, he praised the excellence of Blackstone's arrangement, the variety of his learning, and the purity and elegance of his style. The commentaries were an immediate success in England, but they became even more successful in the US. By 1772, when the American edition premiered, Blackstone had sold over 2,400 copies in the American colonies, nearly as many as in England, in large part because colonials lacked access to the mother country's sources of legal research. The commentaries graced the libraries and were relied on by signers of the Declaration of Independence and the Constitution. Blackstone influenced both Chancellor Kent and Justice Story, who wrote their own significant treatises on law. To be sure, American lawyers did not share Blackstone's adulation of the English constitutional monarchy, his dismissive view of the rights of colonial citizens, and they would not adopt aspects of the law unsuited to our situation. But Americans agreed with Blackstone's ideals. These are, as my friend Professor Presser has said, the systemic nature of law, its divine origin, its moral superiority and moral clarity, and its notion that precedent should govern. Blackstone starts the commentaries by discussing the nature of laws in general. And he writes, quote, "Law, in its most general and comprehensive sense, signifies a rule of action and is applied indiscriminately to all kinds of action. Thus we say the laws of motion, gravitation, optics, mechanics, as well as the laws of nature and of nations. According to Blackstone, law exists in a hierarchy. At the top is the supreme beings, God's creation of laws of motion for all created matter. Next are the fixed and invariable laws that govern the natural world, vegetable and animal life. For man, God prescribed the law of nature. Quote, as man depends absolutely upon his maker for everything, it is necessary that he should in all points conform to his maker's will. The Creator gave man the faculty of reason to discover nature's law, and the law of nature regulates and restrains human free will. And that includes, of course, the laws of good and evil. Blackstone summarized God's law for man with a quotation from Justinian. We should live honestly, should hurt nobody, and should render to every man his due. Finally, this law of nature, of human nature, is binding all over the globe at all times and places. And Blackstone adds, no human laws are of any validity if contrary to this. Now Blackstone starts with general principles of man-made laws. First, they must conform and not contradict the laws of revelation and of natural law. These twin pillars, he writes, are the foundation of all human law. But human law operates on many points of what he calls indifference, in which both divine and natural law leave a man at liberty, and yet society benefits from the regulation of conduct. Among men, there is also the law of nations, because, as Aristotle agreed, man was formed for society. Societies have existed in different places, and the law of nations, which partakes of both natural or positive law, regulates their mutual intercourse. Now, again, I add, I'm not going to analyze Blackstone's political theory. I will not debate his philosophical consistency, whether he was more inclined to the views of Locke or classical natural law. Some of my former clerks in this audience are much more skilled than I in those debates. And no doubt Calvin Coolidge, who was skilled in Greek and Latin and educated in the world's classics at Amherst, himself was familiar with Aristotle, Cicero, Hobbes, and Locke. But for the purpose of legal training, like most American lawyers, I believe, he could read the commentaries and comfortably assimilate Blackstone's amalgam of natural law and natural rights. Blackstone moves on to a concluding his general hierarchy of law with his discussion of municipal law, which governs districts, communities, or nations. He defines the elements of municipal law as a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. He expands upon each component. As a rule of civil conduct, municipal law regards a person as a citizen bound to duties to his neighbor, which means that he contributes to the subsistence and the peace of society. And as a rule, a municipal law is not a promise. It obliges one to act or not to do something. That the law must be prescribed means it's publicly known, and it must be promulgated by the sovereign. In sum, commanding what is right and wrong, the law must declare the rights to be observed and the wrongs to be eschewed. However, he points out, those rights which God and nature have established and are therefore called natural rights, such as life and liberty, need not the aid of human laws. They are invested in every person. In sum, Blackstone's hierarchy of law established the framework for American legal training, legislation, and law practice in America for at least 100 years. The bulk of his commentaries, I'm not going to go into all of those, of course, go on and organize the law systematically. The first volume regards the rights of persons, the second, real and personal property. Volume 3 describes the law of private wrongs, which covers more or less civil actions, and Volume 4 treats public wrongs or criminal law. But important for these purposes is his treatment of the rights or liberties of Englishmen, with which he opens the discussion of the law of persons. To Blackstone, those rights consist in the free enjoyment of personal security, of personal liberty, and private property, so long as these rights remain, quote, inviolate, although subject to restraints for the benefit of society, a person is perfectly free. Note then, he says, both Parliament and the King must protect these rights from violation, but to vindicate the rights, if violated, English subjects have recourse first to the courts, next to the right of petitioning the King and Parliament, and finally to having and using arms for self-preservation and defense. Blackstone's exposition of the rights of persons contributed to the emerging American ideas that the purpose of government is to secure individuals in the enjoyment of those immutable, absolute rights. Through Blackstone, Americans came to venerate trial by jury, the writ of habeas corpus, notions of limited government and sovereignty and judicial independence, though not modern judicial review. He considered rights of property as absolute and being derived from natural law and natural rights. Society, he wrote, had adopted property rights to encourage human productivity and relieve necessity. But property rights were subject to regulation, albeit with compensation for takings. And he said those with a, quote, more opulent status owed duties to the poor. To be sure, there were Americans who criticized aspects of Blackstone's commentaries. Eminent scholars like James Wilson, Thomas Jefferson, St. George Tucker, each had their own critiques, but at the same time, they all recognized the brilliance of his compilation. An author has recently written, all of our formative documents, the Declaration of Independence, The Constitution, the Federalist Papers, and the seminal decisions of the Supreme Court under John Marshall were drafted by attorneys steeped in Blackstone's commentaries. I also read John Marshall, read Blackstone 4 or 5 times. It continued to be the law book during America's formative period, and as Marianne Glendon said, it would be hard to exaggerate the degree of esteem in which the commentaries were held. Before 1900, almost every American lawyer had read at least part of Blackstone. And again, I reiterate, he inculcated in American lawyers that human law derives from, is subordinate to, and answers to God and the moral law, and it may be known from revelation in Scripture and from nature by human reason. He was convinced that English common law was founded on principles that are permanent, uniform, and universal. Blackstone's received a lot of criticism for quite a long time, as I will point out later. But as Professor Albert Alschuler wrote in his defense, the law that he expounded did not hold judges or expositors of the law to an inflexible standard. It did not dictate answers to all or even most legal questions, but it indicated the essential needs of human beings and demanded that people respect the essential needs of others. Now I'll move to the legacy of Chancellor Kent. James Kent lived from 1763 to 1847. As a young law student, he read Blackstone numerous times. He held notable positions during his legal career in New York, 14 years on the state's highest bench, following which, after mandatory retirement, he became the Chancellor of the New York Chancery Court, a post in which he almost single-handedly developed American equity law. He also taught law at Columbia, and from his lectures evolved his commentaries on American law, published between 1826 and 30. This was also a 4-volume work, modeled on Blackstone's format, to describe American law topically throughout the states. By the time of his death, it had gone through 6 editions. The 15th edition was published as late as 1902. Justice Joseph Story, Kent's friend, recognized him as the American Blackstone, describing the commentaries as a juridical classic, which placed their author in the first rank of the benefactors of the profession. Now, Kent didn't have to engage in a taxonomy of the law because, while surveying each specific topic, his work coincides with Blackstone. At one point, he comments, Sir William Blackstone is justly placed at the head of all modern writers who treat of the general elementary principles of the law. His commentaries begin with the law of nations, and like Blackstone, he concludes there's natural and a positive law of nations. And this he posits because states and bodies politic are to be considered moral persons having a public will inasmuch as they're collections of individuals, each of whom has moral obligations. One thing I didn't add was that Coolidge actually spoke very much about foreign policy in the same terms as Kent. But concerning the absolute rights of persons, Kent also derived the absolute rights of individuals may resolve into the right of personal security, personal liberty, and the right to acquire and enjoy property. These rights have been justly considered and frequently declared by the people of this country to be natural, inherent, and unalienable. Writing about the absolute right of property, Kent called it inherent in the human breast. He states, man was fitted by the author of his being for society and government and for the acquisition and enjoyment of property. It is the law of his nature. And by obedience to this law, he brings all his faculties into exercise and is enabled to display the various and exalted powers of the human mind. Because man's creative impetus is encouraged and heightened by property, a state of equality as to property is impossible to be maintained, for it is against the laws of our nature. And if it could be reduced to practice, it would place the human race in a state of tasteless enjoyment and stupid inactivity, which would degrade the mind and destroy the happiness of social life. Translated into modern terms, forced equalization of property destroys the incentive to create and produce. Consequently, Kent said, every person is entitled to be protected in the enjoyment of his property, not only from invasions by individuals, but from all unequal and undue assessment on the part of government. And of course, if the legislature were to take property, which he did not deny the righteousness of that under certain circumstances, a person was owed compensation. What is the, as I, for present purposes, trying to be somewhat succinct, what I call the Founder's Law consists of Blackstone's and Kent's commentaries. It was premised on natural and universal precepts, Judeo-Christian morality, objective standards of right and wrong, and unalienable individual rights, which were inseparable from these precepts. Blackstone, in fact, presaged to an uncanny degree the Declaration of Independence, as he announced that the laws of nature and nature's God revealed self-evident truths, that all men are created equal before the law, all men are endowed with inalienable rights to life, liberty, and the pursuit of happiness. In both commentaries, it is evident government did not exist as an end in itself, but as a guarantor of the individual rights and property rights within the framework of government. Now let's move to President Coolidge. Throughout his public career, he espoused the Founder's Law as the product of reason and revelation. His speeches consistently reflect the commentary's influence, and it is important to recall that President Coolidge was almost the last president who wrote his own speeches. So I'll give you some examples from these. Upon his inauguration as the president of the Massachusetts Senate, he paraphrased Blackstone saying, quote, "Men do not make laws, they but discover them. Laws must be justified by something more than the will of the majority. They must rest on the eternal foundations of righteousness," quote. Legislation, he said, has a higher goal than appealing simply to selfishness. Hence, the laws of the Commonwealth must appeal to man's spiritual nature and must recognize the immortal worth and dignity of man. Such is the path to equality before the law and the foundation of liberty under the law. Again, this clearly echoes Blackstone and Kent's principles. Speaking to an alumni college dinner for Amherst, he extracted from Blackstone that the process of civilization is due to the discovery by men of the laws of the universe and living in harmony with those laws. And he added, for men, the laws of human nature are the most important. Not long before he became president, on the sudden death of President Harding in 2023, he quoted Blackstone directly in a speech to the New York convention of the YMCA. Quote, "By law is meant a rule of action," close quote. And he expanded on the definition, adding that action depends upon intelligence and motive. If either of these be lacking, action fails and the law fails. A law is useless to accomplish its purposes if it isn't obeyed or enforced. He expressed similar thoughts in a speech to the ABA on the limits of the law, noting that when a broad rule of action is laid down by law, it is the people who must perform. Law must be obeyed and enforced. Principles of Blackstone. And finally, in his inaugural address as president, he grounded the science of government in both past experience and in human nature. President Coolidge also explained that people are entitled to rights of property. His speeches consistently promote the benefits of free enterprise for the well-being of all citizens. He favored lower taxes, he said, because he favored the people. Taxes are paid from the people's substance. This echoed Kent's idea that the people's property should be spared from undue and unequal assessments. And again, speaking to the Massachusetts Senate, he drew on natural law, saying, self-government means self-support. Man is born into the universe with a personality that is his own. He has a right that is founded upon the constitution of the universe to have property that is his own. Ultimately, property rights and personal rights are the same. One cannot be preserved if the other be violated. Each man is entitled to the rights and rewards of his service, be they never so large or never so small. Even his most famous passage of his most famous speech, the inspiration of the Declaration, which he delivered in Philadelphia to celebrate the 150th anniversary, implicitly recalls Blackstone because, after all, he quoted from the Declaration the self-evident truths that all men are created. For shortness, I'll say, and Biden said, et cetera, et cetera. But as we have seen, these are premises of Blackstone as much as Jefferson or Locke. And Blackstone's phrasing of these truths was remarkably like that used by Jefferson. Coolidge then explained these propositions in his speech by asserting that the Declaration's ideas are final. This is almost an aphoristic expression. If all men are created equal, that is final. If they are endowed with certain rights, that is final. If government depends on the consent of the governed, that is also final. Responding to those who advocated more modern approaches, he insisted that any other attempt to organize government would represent not progress, but regress to a period when there was no equality, no rights, and no consent. Those advocates of modernity, he said, were the reactionaries. Blackstone and Kent would have agreed. Calvin Coolidge's approach to the founders' law was still widely accepted within the legal profession during the first part of the 20th century. In fact, in the 1920s, a tablet was dedicated to Chancellor Kent as the American Blackstone in the New York Court of Appeals. But he recognized that the founders' view of law, and indeed of American political institutions, was under assault. Now, the full tale of the decline of Blackstone and Kent in American legal education is beyond the scope of these remarks. It started in the political and religious discourse of the 17th century. In Blackstone's own time, Jeremy Bentham became a virulent enemy of his former teacher. By the 19th century, theories including skepticism, positivism, theories articulated by Marx, Hegel, and Darwin, each played a part in undermining the traditional underpinning of American law. As early as 1872, a young law graduate named Oliver Wendell Holmes was tasked with editing the 12th edition of Kant's Commentaries. He bemoaned in a letter, "I have to keep a civil tongue in my head while I'm his valet. He has no general ideas except wrong ones, and his treatment of special topics is often confused to the last degree. A youth never in doubt." These modernist ideas inspired the development of progressivism and legal realism. Generally, the legal realist movement threw over the concept that law is tied to moral judgment and right reason. Legal realists contended that the founders' law had become stultified, mechanistic, outdated, and unresponsive to social problems. They also claimed, as Charles Evans Hughes had said before he went on the bench, that the Constitution, meaning and law, is what the judges say it is. At their best, the legal realists and progressives advocated incremental changes that could simplify legal concepts and adapt common law principles to the needs of society. At their worst, progressives, led by intellectuals like Woodrow Wilson, deliberately sought to undermine the government created by the Constitution and to supplant it with government by experts. And at their worst, adherents of legal realism and subsequent non-traditional theorists authored The Skeptical Jurisprudence of the 20th Century, which, as Professor Alshuler said, defamed the thought that preceded it. Perhaps the most famous example of defamation is, again, from Holmes, who's made the canard that natural law was a brooding omnipresence that oppressed the legal system. We must never forget that Holmes also authored Buck versus Bell, which condoned forced sterilization of someone thought to be mentally inferior. 20th century legal theorists have essentially abandoned any relationship with the founders' law in favor of raw positivism. Positivism, very simply, means that the lawgiver, led by his internal compass alone, dictates the rule of action which must be obeyed. Transforming legal education from appreciation of the founder documents and commentaries to the case law method reinforced this idea of relativism that has taken over. In the give and take of the Socratic discussion of cases, law students are led to infer that case law can stand for any, even conflicting propositions, and all propositions are equally valid so long as you can get some judge to accept them. Modernists dismissed as self-contradictory the traditional canons of interpretation of legal texts. Along with devaluating texts and rules of grammar, they claimed that the words of the Constitution and statutes were vague generalities into which modernist judges could and did pour their personal ideas of social reform. How far have modern 20th century legal theories departed from the founders' law? Let me count the ways. Number one, they're utterly disconnected from revelation. They have forsworn that human law is answerable to God in any way. Number two, they abandon the concept of universal, changeless human nature. Number three, they refuse to acknowledge rules of moral conduct and objective tests of good and evil. Number four, they denied property rights as an essential aspect of personal liberty. Number five, they devalued the rules of precedent. Number six, they elevated government without the consent of the government. That is to say, government by administrative bodies and, dare I say, judges. Number seven, they used law as a weapon for transient political gain. Number eight, their theories are marked by serious instability. How many theories have we been through in the skeptical jurisprudence of the 20th century? Just a few are legal realism, sociological jurisprudence, process jurisprudence, critical legal studies, feminist legal studies, and environmental justice, whatever that means. Number nine, many of them have come to disavow the Constitution. We've seen editorials by prominent legal scholars who are against just flat against various aspects of the constitutional framework. We have seen others support the outright nullification of federal law and the structural assignment of various duties to various parts of the government and the states. We have seen refusals to enforce laws for public security. We have seen the replacement of rights and the equality of all before the law with tribal-like notions of allegiance. We have seen justifications of political violence, vandalism, and even assassinations. I conclude with these remarks. President Coolidge said, "Governments don't make ideals. Ideals make governments." The ideals of the Declaration and the Constitution were based on ideals expressed by Blackstone and Kent, the Founders' Law. If those ideals have lost their force in the hearts of citizens, can a government founded on them survive? That is the question of our time. That is, to me, the great challenge that younger citizens face. Difficult as things may seem, however, envy is a sin, but despair is a sin. It took an entire century for legal realism and its mutant descendants to arrive at the nihilistic points in which they now exist. Revolt against the premises of these modernist theories was begun for the Supreme Court by Justice Rehnquist around 1976 and in Attorney General Meese's famous speech in 1985. I started on the bench 1 month before President Meese gave his speech throwing down the gauntlet in favor of originalist interpretation of the Constitution. For 40 years, I have attempted and been privileged to try to adhere to the Founders' Law. Despite many setbacks, the Supreme Court and the federal bench have seen a transformation in a favorable direction. I hope that in the future, brilliant scholars, some of whom I can suggest to the supporters of this series, can restore our gratitude for the precious heritage of the Founders' Law, and then restore our institutions in conformity with it. I hope and pray that this series will offer a podium for further recovery of the Founders' Law, and it will honor the legacy of President Coolidge in addition. Thank you very much.
How do you think of this in the context of Adrian Vermeule's common good constitutionalism?
I haven't read much about that, and I just try to follow the Supreme Court. What can I say? I mean, he doesn't, that's all I can say about it. I don't know enough to answer a lot about that. I'd prove my ignorance. Yes, sir. The more I see of conflict among the states and their economic regulations, the more I'm thinking that the Supremacy Clause had a serious purpose in trying to integrate the fabric of the American economy. I'm afraid that the economy is suffering just as much as it's sort of under the radar of the fact that we have these serious red-blue ideological conflicts. I gave a speech some months ago mainly to rile up some other originalists about, I defended the negative commerce clause. And after all, a major reason for convening the framers of the Constitution was the fact that all of the states were conducting commercial warfare against each other in the organization of the Confederation, and something needed to be done about it, and I think we're reaching but I can't, I'm intrigued about Swift v. Tyson. I haven't gotten into the history and the theory of it. Michael.
How does the Founders Law, how should one view the Founders Law if you're trying to interpret the Constitution according to original public meaning?
I defer that one to Hadley.
I studied with him for 2 years, and I know what he would say.
I'm more interested in what he would say than what I would say. I think the Supreme Court and many great scholars have given us criteria or a means and access to looking at original texts that we didn't even have a few decades ago. So it is much easier to draw conclusions about the landscape of law that existed back then and how they thought about things. That's a very general, but that's the way I would go into it, is with a lot of Google searches.